Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner of San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How's it going this week, Miki?
I'm doing well. How are you, Kim?
I'm doing good, thanks. Coming back from LA, and it's good to be back here in San Diego. This week, we are discussing several immigration updates, updated guidance on the H-1B Proclamation, a change in USCIS payment methods, the new parole fee, and the H-4 EAD program. So we're going to break these down. Yesterday, which was Monday, USCIS updated its website on H-1B petitions with some clarifications. So the upshot is that the $100,000 fee applies to new H-1B petitions filed on or after September 21st of 2025 for H-1B filings that, one, it's for H-1B workers who are outside of the U.S. who do not hold a valid H-1B visa, and two, applies to petitions requesting a consular notification, port of entry notification, or pre-flight inspection. Those are for people who are not maintaining valid status in the United States. This actually confirms our earlier speculation about the narrower scope of the proclamation than was initially announced. So, can you tell us more about who is exempt from this $100,000 fee?
Absolutely. So the $100,000 fee does not apply to people whose employers file petitions that request amendments and extensions of stay and are approved as such. So, although change of employer petitions or H-1B transfer petitions are not specifically named, we do believe that is covered by extensions of stay that are not subject to the $100,000 fee. The guidance also confirms that change of status petitions are exempt from the fee, provided the individual remains in the US while the petition is in process. So, beneficiaries of those petitions that are approved as amendments, change of status, and extensions would not be subject to the fee if they later depart the US and apply for a visa based on the approved petition. The guidance also confirms that people whose petitions are filed as amendments, change of status, or extensions would become subject to the $100,000 fee if the USCIS approves the petitions as consular notification, port of entry notification, or pre-clearance notification cases. For example, even if the petition was filed as an extension, if the beneficiary is found to have not maintained valid non-immigrant status at the time of filing, USCIS would adjudicate the petition as a consular notification case. And similarly, a change of status request to H-1B from another visa status could be approved as consular notification and trigger the fee if the foreign national travels internationally while the petition is in process.
Yeah, that's right. And as we already know, people who have a valid H-1B visa foil in their passport and people who had an H-1B petition filed on or before September 21st are exempt from the fee. It's also worth noting that it is still possible that the courts could strike down the proclamation. A second lawsuit was filed by the U.S. Chamber of Commerce in the District of Columbia, whose arguments overlap with the first suit that was filed earlier this month by another group in California. This suit also argues that the proclamation is unconstitutional because it exceeds the presidential authority, goes against provisions of the Immigration and Nationality Act, and that the proclamation violates the Administrative Procedures Act. So, yesterday's update from USCIS also confirms that employers would submit the $100,000 fee by using pay.gov. So, it appears that the payment method is now activated on the USCIS system. The USCIS website also now indicates that requests for national interest exceptions, which are also referred to as NIEs, are to be submitted with supporting evidence to H-1B exceptions at hq.dhs.gov, which is a new email that's been created. This new guidance seems to depart from the standard announced in the proclamation, which was essentially that entire companies and industries, in addition to specific individuals, could be granted NIEs. The USCIS guidance indicates that NIEs are for extraordinarily rare circumstances where the Secretary has determined the H-1B worker's presence in the U.S. is in the national interest, that no American worker is available to fill the role, that the alien worker does not pose a threat to the security or welfare of the United States, and that requiring the petitioning employer to make the payment on the alien's behalf would significantly undermine the interests of the United States. Miki, let's now turn to the other updates we have for today. And can you tell us about USCIS's change in filing fee payments?
Yes, as of October 28th, USCIS is no longer accepting paper checks or money orders for filing fees. They're only accepting ACH debit transactions and credit card payments as of that date. For immigration programs that normally pay their immigration counsel to handle payment of filing fees, there really isn't any impact that you would feel directly. It's really up to counsel to handle that internally. But for programs that either don't work with counsel or provide paper checks to counsel to include with the petitions or applications that are submitted to USCIS, they will need to start using Form G1650 for ACH transactions or Form G1450 for credit card payments. A separate form is required for each application, petition, or request.
Thanks, Miki. And next up is an update on new fees for parole applications. So last week, USCIS published a notice announcing a new fee of $1,000 effective immediately for certain categories of parole applications. So, as HR and global mobility professionals know, in the immigration context, parole is not related to crimes. It relates to the temporary permission from the US government to enter the US for specific reasons. So, this new fee applies to individuals who are paroled into the US, even if they have already filed a request for parole before the effective date of October 16th, 2025. The fee triggers when the parole request is approved and the individual is actually entering the United States. Parole also applies to people who are already in the United States and seeking approval of their parole from ICE, custody, parole in place, or reparole. Miki, can you discuss who the fee does not apply to based on the exceptions provided by the government?
Yes, absolutely. And, we wanted to discuss this to dispel any confusion on the part of global mobility and HR professionals who may have heard about this new fee and may not be clear on whether this impacts their employees. So, the good news is that pending adjustment applicants are not subject to this fee. So, for context, foreign nationals who had filed their final step of the green card process from within the US, called Form I-485 Adjustment of Status Application, can apply for their travel permits as part of the process. And this travel permit is called an advance parole. And so the USCIS has made it clear that people traveling back to the US on advance parole for people in that category are exempt from this $1,000 fee. The fee does apply to many humanitarian and discretionary parole grants, including those on humanitarian parole programs like Uniting for Ukraine, as well as people with temporary protected status or DACA that apply for advanced parole not associated with a green card case. It also applies to people requesting parole for medical or hardship cases and military family members who are applying for what's called parole in place from within the US. And there are carve outs exempting people applying under certain categories, like people with medical emergencies, people with close family members who are facing imminent death, or if they're attending a funeral. Also, adopted children needing urgent medical treatment before their visa is issued, and a few others. The new fee will apply even to cases already filed if parole is granted on or after October 16th, because the fee is triggered when the parole is granted upon their entry into the United States.
Great. Thanks, Mickey. And so let's now turn to the good news about the H-4 Employment Authorization Program. So on October 14th, the U.S. Supreme Court declined to hear the case that challenged the legitimacy of the 2015 DHS rule that provided employment authorization eligibility for the H-4 spouses of H-1B workers. So under this program, H-4 spouses where the H-1B worker had an approved I-140 immigrant visa petition or had an extended H-1B status beyond the 6-year limit based on a pending green card process have been eligible to file applications for what we call an EAD, an employment authorization document. So a group called Save Jobs USA brought suit challenging this rule. The federal district court and the circuit court of appeals had struck down the challenge, and then the group appealed to the Supreme Court. On October 14th, 2025, the Supreme Court declined to hear the case, which means that the Circuit Court of Appeals' prior decision to uphold the H-4 EAD program still stands.
That's right. The H-4 EAD program was also at risk through the regulatory process. Under Trump 1.0, the Department of Homeland Security attempted to eliminate the program by issuing regulations, but those efforts were not successful because they were not promulgated prior to the Biden administration coming into office. The rescission also meant significant pushback from the business community. The appeals court decision to uphold the H-4 EAD program and the Supreme Court declining to hear the case doesn't necessarily foreclose a future attempt by the administration to issue an end to the program through the regulatory process, but the court's stance on it is certainly helpful.
And before we wrap up, Miki, you're speaking at WRC Global 25 next week. So why don't you tell us a little bit about that?
Thanks, Kim. Yes, I'm headed to Salt Lake City to attend WERC Global 25, and I'll be speaking on a panel called Beyond the Numbers, using benchmarking to drive global mobility strategy. So it's all about how global mobility leaders can use data through peer benchmarking to help drive their decision making and compliance and communication management and other key important topics in mobility. And for those attending, please pop by the WR Immigration booth 519 and say hi to us.
Oh, that sounds awesome. I hope you enjoy Salt Lake City. Have a great time there. And I think with that, it wraps up this week's Rapid Fire Wednesday. We will, as always, continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. As always, for all the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thanks for joining us, and we'll see you next time. Great seeing you as always, Miki, and have an amazing time at WERC Global 25 in Salt Lake City next week.
Thank you. Good to see you, Kim.